Hi everyone, welcome to another team video for the SALTovation group. Today, Stacey and I wanted to just kind of talk through some of our initial thoughts about the complaint filed with the state of New York for ACMA. You know, she and I had the privilege of talking with ACMA directly and their attorney on their California case. And in one of our podcasts, so we have a longer kind of discussion with them and wanted to kind of talk through some of our initial thoughts about that complaint. So Stace, I don't know, you want to kick it off?
Sure. So just for everybody's, just to kind of go back on memory lane here, for California, the ACMA actually won their case, but it was really based on a procedural kind of glitch. And the fact that California did not go through the proper kind of regulatory process in order to pass the legislation. Now we have a situation where New York at the end of 2023 passed a regulation and so obviously went through the proper channels. And so now we have a regulation that was passed in New York where the internet activities that the MTC had put out in their expanded guidance from a few years ago on Public Law 6272, where those internet activities are now part of basically almost verbatim the regulation in New York. So you have cookies on your machine, you have online applications, some of those internet activities. Now, those, if a taxpayer were to engage in those, New York would say that those would fail Public Law 6272 protection. Again, there are some devils in the details there, but by and large, if a taxpayer is engaging or has an interactive website where those kind of activities are able to be engaged in, then now we have a situation where in New York, for corporations, very specifically to corporations, then those activities would be deemed to be exceeding Public Law 6272 protection. So few things here, right? Basically, they took the MTC guidance almost verbatim, put it in the reg. Only applies to corporations so far. And then the other thing that I think taxpayers need to remember is that New York has a factor presence standard for income tax nexus for corporations only. It started at $1 million, but it has been adjusted for inflation as time has gone on. So it's over $1 million now for the 2024 tax year. So we've got a couple things to kind of, I think, for taxpayers to think about with respect to the fact that we've got this rule on the books. We've got a factor presence nexus rule that's pretty high in New York, but New York's a big state, a lot of business in New York, so it's conceivable that a lot of taxpayers might exceed that threshold for corporate purposes, and then now layer in the fact that we might not meet Public Law 6272 protection, depending upon the activities that a taxpayer is engaging in. So the ACMA, right, they're challenging this rule. A lot of their arguments are around the fact that Public Law 6272 is a federal law, and it would take Congress to make a change that's as sweeping as this MTC guidance that New York and also New Jersey have put in their statutes and regs. So that's the crux of really the ACMA's argument. And we'll just have to wait and see whether this has teeth and whether this case actually does maybe get elevated up such that we might see a stop to it, let's say.
Yeah, and Stacey, something that you kind of were quick to point out is the retroactivity associated with that, and in the complaint, what it going back to 2015,
Yes.
and kind of right initial reaction is like, okay, well that's out of statute, right? But if you are a corporation never filing a return, right, you don't have a statute of limitation,
Right.
So that's thing number one, and especially much to many surprise when you think about New York as a whole, is you do not have to file a tax return to claim 86272 protection like you do in California and a lot of Illinois, a lot of other kind of big states like that. So you are on the hook then for if you never filed a PL 86272 protected return, right? You could potentially have to go back to 2015. And I think that's against some of the recommendations when kind of this modernization, so to speak, was to not make it retroactive.
Right.
Right. So there is just some conflicting
and
items rolling through this that are kind of a big deal.
Correct. And I think, they also do mention Wayfair, which we all know is a sales tax case, but a lot of what the courts decided, why they decided in Wayfair, partially why they decided the way they did in Wayfair, that you can have economic nexus, is because the South Dakota sales tax system there was not really like an undue burden put on taxpayers because their system is their sales tax system is pretty straightforward, right? And so the ACMA is arguing, just to, follow on, Meredith, to what you're saying, is that they're saying, well, you're putting an undue burden on taxpayers by making this retroactive as well. So it's got a lot of problems. Not only do we have, it's a federal law going to be applied retroactively in New York. So it's conceivable that auditors are going to be looking at this, and or to your earlier point, if they don't have a return on file, because if you're protected in New York, then you didn't have to file. So then they could be getting tax returns back to 2015. All of it is just very much an undue burden on taxpayers. So that's a lot of what they're arguing, and hopefully we'll see, again, these cases take a very long time to make their way through the system, but the hope is, and ACMA is holding out for, is that, they're going to bring some of this to light, and hopefully then other states will not join on or jump on the bandwagon per se,
right?
And also start to pass these rules. I mean, I think that's our concern, is that we do see the New Yorks, the Californias tend to be the ones that are out there, in the front runners to
kind of taking the heat for everyone.
Well, right. And, a lot of other states just kind of wait in the wings to see what they're going to do. And so I think that is a concern that we have, that, okay, New York now has this regulation and we're kind of stuck following it until something happens with this case, which, as we know, could take some time. So then in the meantime, are we going to start to see more states jump on this bandwagon? And then, the ACMA might be busy filing more suits in other states, unfortunately.
Yeah. Well, and I wonder if they're going to make, at some point, like a discriminatory argument, right? Because if you have PL 86272, the kind of expansion for corporations only, and you have old 86272, because again, it's a federal law, so it applies to all businesses conducting businesses and activities, right? You get some favorable-ish, right, unexpanded treatment from a pass-through side, but at the same time, the pass-through kind of rules don't have the $1 million threshold, and there are different, nexus requirements, So it's very kind of it's a really interesting kind of distinction that New York has made, that I don't know that all the other states really have, that bifurcation and
Right.
differing treatment between, pass-throughs and corporations.
Right. Yeah, I mean, the New York rule is very specific to corporations. And the way that they put it was really in their nexus rule, which is why then the $1 million or now $1 million and above threshold, it's twofold, right? So it's the $1 million and above threshold plus then the PL 86-272 activities. So it's all part of the same regulation. So I guess it remains to be seen, will they address pass-throughs separately? Will they not address them? We'll have to wait and see if that even becomes an issue from the state's perspective.
Yeah, so lots of fun for us to watch. Thank you, ACMA, our friends over there.
Leading the charge.
Leading the charge. For those listeners, if you want to join ACMA, contribute to them, help the good fight for clarity. I think they would greatly appreciate that. And so I think that's it for now. And as we know more, you'll know more. So thanks for stopping in, everyone. And until next time.